Good morning, Judge Glacier. It looks like we have the attorneys for either party as well as the court reporter that I can bring in when you're ready.
Great, I'm ready. Thank you, Morgan. Okay, good morning. Can everyone hear me?
Yes, Your Honor.
Good morning. Let me call the case. I see our court reporter is here. Great. Thank you, Ms. Godwin, for coming. This is City of Grand Ledge versus Michigan Department of Environment, Great Lakes and Energy. It's Court of Claims docket number 21209MZ. And we are here today because I have read the briefs. I've read all the exhibits. I've thought about this case and I had a few questions and I thought that argument would be helpful. So counsel, could you introduce yourselves?
Good morning, Your Honor. I'm Jillian Wenner here on behalf of Eagle.
Good morning, Your Honor. Charles Barbieri, along with Mark Kerner, who is in the background for the City of Grand Ledge, the plaintiff.
Great. Thank you both again. Let me get things started by telling you where I am in terms of my thinking, and I'll save everybody time by focusing all of us on the issues that I think are most pertinent. If I've misidentified the issues, however, you should feel free to steer me in another direction. This is my first case involving a well or involving the water system of our state. So this was all quite new to me and interesting, I must say. The Court of Claims delivers some cases that I will call less than interesting, but this is not one of them. This one I actually felt like I learned a lot. It seems to me from reading everything that in many ways, this case really comes down to what happened in 2009 when municipal users, other users of water were required to identify their baseline capacity. Not only were they required to, in a general sense, identify the baseline capacity, but in a specific sense as well. That is, they were required to identify each and every well that was being used to supply water to the system. For reasons that we can debate, well 9 was not identified at that time as part of the City of Grand Ledge's baseline capacity. And as I see it, this case asks the court to decide, is there some legal exception that would allow the city at this point to bring that well into its municipal water system? Or if there's no legal exception, and by legal, I mean statutory, common law, although I don't think there's any common law at all on this subject, but so let's stick to statutory, regulatory. Is there any legal way to get that well into the system? Or for lack of a better way to put it, should the court essentially create one? And as much as I sympathize with the city's plight here, I can't really come up with anything that would help the city in this case. It appears to me, and I'll be quite blunt with you, that Eagle has the better argument here. One of my questions that perhaps, Ms. Wenner, you can help me with is, actually, I have two questions that I would like you both to address. And of course, you can both take your time and address that which I have just laid out for you. But is there a difference? Here's one question. Is there a difference in the permitting process between the Safe Drinking Water Act and Part 327? And if there is a difference, what is that difference and why does it matter? And the second question, I think I know the answer to, but I would like your input on it. It appears to me that the state never approved well 9 for the type of use that the city now contemplates. I see some indication in the record that the city was possibly allowed to use that well for what I'll call limited water withdrawals. But, and this is confusing to me, that apparently was not a permit to use the well under either the Safe Drinking Water Act or Part 327. So with those thoughts out there, Ms. Wenner, I believe it's your motion. It's been a while now since I looked at it, but I think it's your motion. So please proceed.
Let me start with your general thoughts. And I think that you've really nailed the essence of the baseline capacity issue here, that there was a statutory deadline and we're looking to revise that deadline here. And, you know, sympathizing with where they are now kind of misses that they were able to consider these potential consequences and costs at the time. As to your question about the difference in the permitting process between the Safe Drinking Water Act and Part 327, those are concurrent. So when you are getting a Safe Drinking Water Act permit or doing the assessments required under Part 327, those things are happening at the same time and are kind of rolled together. And that is in the statute. The Safe Drinking Water Act refers back to Part 327. The differences between those two statutory provisions is that the Safe Drinking Water Act is under the Public Health Code, so it's about the safety of drinking water for people and public health. And then for Part 327, it's about the adverse resource impact of withdrawals to the Great Lakes Basin or to our water or groundwater supplies. So it's a little bit more environmentally focused, but they do run together because they kind of they occur simultaneously, I guess. And as to how it matters, I'm not so sure how to exactly what you are asking about the significance of the differences. So I hope that those explanations are sufficient to address that, but if not, please let me know.
It sounds like they're really, that the difference, there are two statutes that get to the same point. Maybe that's the way I'm thinking of it now. They get to the same result. So they're additive, or as you said, concurrent, but they don't provide different avenues to permitting. They work together to provide one sort of route to permitting. Is that correct?
I would say that the Safe Drinking Water Act is the avenue to permitting, and then Part 327 gets rolled in if you're getting a Safe Drinking Water Act permit. But if you are getting a different type of withdrawal permit, then Part 327 is, you know, the first stop.
Maybe I don't want to know, but what other kind of permit is there besides a Safe Water Drinking Act permit? I
can't tell you off the top of my head. I'd have to go look at Part 327 in more depth. But whatever it is, it's not relevant here because they want the permit for safe drinking water. Precisely.
Right? Okay. So, okay, go ahead. I keep going.
Would you like me to address your second question?
Yes,
or
please.
Okay.
Yeah.
So as to your question about the Eagle never having approved well 9 for the type of use that the city now contemplates, but possibly having allowed it for limited use, in the letter where Eagle says the pumping rate will apply to this well, what Eagle also says is that rate will only apply to this well if you get it permitted. So yes, it is true that the state never approved well 9 for the type of use that Grand Ledge seeks to use it for now. And in order for them to use it in the way that they want to, they always needed to get that permit. There's adding capacity to your system is an alteration that requires a permit under the Safe Drinking Water Act.
Okay, that's helpful. Thank you. Mr. Barbieri?
Thank you, Your Honor. Let me address your issues in this order. I'd like to address your questions and then go back to your original proposition, which I would like to discuss, because I believe that even if the court does not agree with some of the arguments that I'm making, the estoppel argument allows for the court to exercise the authority that this case is about. Turning first to your question, is there a difference in the process in the Safe Drinking Water Act in Part 327? I submit that it depends on the circumstances that you find yourself in. If you were to do a request today for a new well, you would have, as part of the process, to either get or simultaneously receive a permit under the Safe Drinking Water Act, specifically MCL 325.1004. And then you'd have to seek, if you're a large quantity water withdrawal, a permit under the Part 327 at MCL 324.32723. However, in this instance, we do not have to go through that exercise because, in fact, this well, in our view, is part of the baseline capacity and therefore does not have to go through that Part 327 process. So, Your Honor, respectfully, I would probably say there is a difference here in that our circumstances allow us to avoid having to seek that determination. Now, I will, without trying to complicate matters further, indicate that within the Safe Drinking Water Act statute, they talk about a new well having to go through water withdrawal reviews and approval. So today it's different, but we're talking about a well that was in existence back in the late 1990s, was recognized as having a capacity of being able to pump well in excess of 100,000 gallons per average per day on average for over a consecutive 30-day period. So in our view, we don't have to go through the exercise of Part 327. We merely need to get the permission for the pump to be added and the pump house to be constructed so that the well is fully operational. We submit that back at the time of the 2009 time period, it met the definition of being a well capable of producing a large quantity withdrawal, and that's the key test. Now, I'll get to the point in a few minutes as to why I think there is an estoppel argument, but I want to point out that it was not incumbent upon us necessarily to come up with the exclusive list or the sole list. It, in my view, was also part of the department's responsibility. And we submit that the form did not give our client sufficient notice of what the complications would be if for some reason in filling out a form back in 2006 or 2007, and if not amended before 2009, would have the consequence we face today. So, Your Honor, respectfully, we submit that all circumstances that exist here, as shown by Exhibit B, the well was capable of producing well in excess of 100,000 gallons per day. It was in existence. It was recognized as being part of the well program that the city of Grand Ledge had. It was in the well field. A decision was simply not made at that time to make it operational because the need did not exist and the cost did not justify what we find ourselves today in.
Let me stop you for a second. Let me stop you for a second because I have to disagree with part of what you're saying. The letter that Eagle sent to the city in 2007 said, and I'll just read the key sentence, at least the key sentence as far as I'm concerned. Eagle listed the drinking water wells that it had knowledge of and their capacity. And then the second from last sentence says, if you have additional wells that were in operation by May 29, 2006, add those wells to the list below. So, you know, the city was clearly invited as to add well 9, and it didn't do that. I can't place any blame whatsoever on anyone other than the city, given what I view as the exquisite clarity of that request by Eagle.
May I respond, Your Honor?
Sure, of course.
Yes. My view is, Your Honor, this is a collective enterprise, not one exclusively dependent on my client, the city of Grand Ledge, in making that determination. I believe that the terminology here was probably perhaps the fatal flaw, if you want to call it that, in this reporting form, because it uses the word operational. This well existed. This well was capable of producing. And if you go to Part 327, it doesn't tie itself to whether it was operational in the sense of having a pump or a pump house. It was based on whether it was a well capable of producing 100,000 gallons per day on average for a consecutive 30-day period. It certainly meant that. No one's objecting to that as far as I can tell here. So perhaps the terminology itself was the fatal flaw here, but I don't believe my client should pay the consequence for the circumstances it now finds itself in entirely. Let me just go to the estoppel argument. I was going to wait and cover the isolation zone issue first, but let me just respond to that point. I believe that my client has legitimately relied on the circumstances of the communications that have occurred with the department over the period of time, beginning with 1999 through 2016. There was no indication that my client would not have that well available to itself, Part 327 notwithstanding. 2003, that well existed. It was capable of producing a large quantity withdrawal. You have in September of 2006 recognition that that well could be operational, and that you have in 2009 continued reflection of that fact, and again in 2013, all during that period of time, as shown by the exhibits that have been presented to Your Honor. We believe that there was a justifiable expectation that there would not be an additional hurdle above and beyond, which is the normal case of seeking the plans and specifications for the pump house to be approved for the well's activation. It's been converted and hijacked now into having us do additional steps for purposes of demonstrating no adverse resource impact. And quite frankly, that takes us down an odyssey from a timing and cost standpoint that we believe is unreasonable. We've justifiably relied. We've maintained this well field. We have included well 9. We are invested in this. We are spending up to $13.5 million currently for the purpose of putting in an iron removal. The alternatives, as the court is well aware from our brief and our pleadings, is adds the added injury of $24 million when we believe it's perfectly reasonable for this court to conclude that the state should be equitably estopped. Let me just turn briefly, in the interest of time, to the isolation zone argument. Has not been as prominent thus far in the argument, but I simply want to indicate that if you look at the rules as they cite them, and you are looking at rules 325.10809, 325.10802. We submit that the approval already occurred for the isolation zone. It's evidenced by the exchange that occurred back in 1999. It's evidenced by the communication in 2003, and has been evident throughout that period of time. We submit that the approval occurred when the well was installed, tested, and was available to be in use, subject to having the pump house added. Yes, it should be inserted in the permit conditions, and that can be done as part of the pump house, but the approval itself, in our estimation, has already occurred. If the court were to disagree with that analysis, again, we believe that we've justifiably relied on that question being answered some time ago. All the contamination sources that they now claim exist and are problematic were there back in the time when this issue was looked at in 1999 and 2003. We do not believe that a new approval process is justified or necessary. We believe there was a reasonable expectation. We've relied upon it again in developing this well field and maintaining its existence. So respectfully, we submit that estoppel would apply here too, if the court believes that approval has not otherwise been granted.
But approval, I mean, approval was never granted, as far as I can tell. A permit was never obtained for use of that well.
I agree that you need a permit reflecting that condition. Where I perhaps have the disagreement, Your Honor, is that I believe the approval already occurred. It just merely needed to be reflected in the permit condition. But
when did the approval occur? What exhibit shows us that?
Well, two in our estimation, at the very least. One would be the Exhibit C, which is the Pat Cook email or facsimile. And then also, I believe it's Exhibit D, which I believe is the 2003 letter, Your Honor, that was provided to my client. There was no indication in that there would be any isolation zone issue. And certainly after the 2003 time period, there's been no indication of that being an issue, and until we find ourselves in the situation of the communications that have occurred since 2018.
Okay, well, I have Exhibit C in my hand. I mean, I don't know how a fax asking questions can be a permit. That I'll say. And Exhibit D specifically says, please note that this letter is not a construction permit. So,
Honor,
I think this is a hard road for you. But let me ask you this. I mean, if the court says no to you, that means you have to go get the permit, right? The city has to go get the permit. And what I'm hearing you say is, but correct me again if I'm wrong, we can do that, except it's very, very expensive.
If the permit requires us to re-argue matters that we believe are decided, whether it's in the form of the isolation zone or the Part 327 baseline capacity, we submit that adds to the load, if you will, of what should be, in our view, a relatively straightforward request for a permit for the introduction of the pump and the pump house that's necessary for the operation of PW9.
Okay. All right, Ms. Wenner.
Thank you, Your Honor, by the way.
Thank you.
There are just a couple of points that I want to touch on. First, that the statutory definition says who does define a supply's baseline capacity, and that's the supply itself. And it's also clear as to how they do it, which is by its reporting to Eagle. We also object to the claim that it was capable of producing because it was not equipped with a pump. I guess I want to jump to the estoppel arguments that opposing counsel was making about them not going through the reasonable process that applies to everybody, that Eagle is asking to add additional hurdles. But what is the case is that this is actually the normal process, the normal proceedings. What they are asking for is what is actually different. And as to the facts in Exhibit D, I agree with you that they do not say what they have been represented to say. And that Eagle has been clear in all of the communications cited, and the exhibits to the complaint that address this are going to be C, D, E, F, G, and I, that there is no permitted capacity for PW9, there was no approved isolation area, and that if Grand Ledge wanted to bring PW9 online, it would need a permit and all of the review required in order to get that permit. And that is,
okay, is there any reason you know of that they can't get the permit if they go through the steps that Eagle wants them to go through?
I don't know if that can be said until the permit application comes to Eagle. We don't know exactly what they would be applying for, and I wouldn't know that as of now. That's a hypothetical that it's reaching kind of beyond the questions being asked.
Okay. Okay, well, this was helpful, and I'm grateful to you for coming via Zoom. I saved you all the trip to Detroit, which is one of the things I like about Zoom. But I think I understand things much better now, so I appreciate it. And I will do my best to get an opinion out by the end of the week.
Thank you, Your Honor.
Is that?
Thank you, Your Honor.
Thanks again. And Ms. Gadwa, I think the court would like a copy. It will be helpful just to order a copy for the court. That way, if anybody wants to claim an appeal, they can have a heads up on that. So let's do that.
Yes, ma'am.
The court will order it. Great.
Okay. Would either counsel like a copy?
I would, Your Honor.
If I could get your contact information to get in touch with you about that, I'd appreciate that.
Absolutely. Let me put it in chat for you real quick. This is my email address. Okay, it is now in chat. It's rdgadwa1956@gmail.com.
Great.
Thank you very much.
Okay,
quite welcome.
thank you all. I'm gonna leave. Appreciate it again. Have a good one, guys.
Thank you.
Thank you, Your
Thank
Honor.
you.
Bye-bye.